Hi everyone, my name is Shazia Khan and the unit we'll be looking at today is Unit 3.29, which is Legal Terminology and Communication. And the learning outcome that we'll be looking at today is Learning Outcome 3, which is to be able to communicate legal information in writing. Before I proceed with looking at the elements of Learning Outcome 3, we're going to summarise what we did in the last session, which was Learning Outcome 2. So in the last session, we looked at Learning Outcome 2, which is oral communication and different styles. So we looked firstly at what oral communication is, which was the process of exchanging information, thoughts and ideas through spoken words, and it is a fundamental form of human communication that allows individuals to interact, express themselves and convey messages directly to others using speech. Oral communication covers a variety of aspects, such as speaking, listening, and understanding. It is a dynamic process involving both verbal and non-verbal cues, such as, the tone of your voice, your facial expressions, your body language, etc. We then looked at the nature of oral communication, why it's so important, why people rely on it, and why organizations use it. We then went on to look at the purpose of oral communication, which is to effectively convey information through clear and concise vocal words. It is there to foster interaction and relationship building and facilitates collaboration among individuals. Effective oral communication skills are vital in personnel and professional settings as they enable individuals to express themselves, listen actively and respond appropriate to the needs of others. We then looked at the types of oral communication, and the main one and the most popular one is face-to-face communication. And this is when two or more people interact and communicate while visible to one another. And this is often the most effective form of communication, and can then written or audio conversations. This is because, you see one another and allows to pick up non-verbal cues and body language. Good leaders tend to use face-to-face communication. We also looked at speeches and presentations and why they were so important. We looked at the different types of oral communication, such as group discussion, and that involves multiple participants engaging in an exchange of ideas, opinions, and perspectives. Then we looked at public speaking. This is a type of communication which involves one individual speaking to a large group of audience. Interviewing, video conferencing, telephonic communication, and informal conversations. We then went on to look at role of argumentation in law, why it's so important and why it is needed in law. And it plays an important role when someone presents a legal claim and wishes their claim to be accepted by others. A lawyer who brings a case to court must justify his or her case with arguments. Communication skills are essential for lawyers to effectively communicate with clients, judges, jury, and other legal professions. Lawyers must be able to explain complex legal issues in simple terms and persuade others to the point of view with negotiation. And then we looked at the relationship between dialectic and rhetoric, questioning and techniques. We then looked at the logical approach of legal argumentation and why it's important, and we looked at the issue in regards to why there's a need for legal communication. We looked at the academics' views on rhetorical approach. We looked at the audience analysis in oral communication. We also looked at the 4 Ps in legal argument, which is planning, practice, preparation, and performance, with reference to what is needed for each one. And then we summarised the importance of oral communication within the legal profession. Now we're going to look at identifying, being able to communicate to legal information in writing. So we will be covering communicate legal information in writing using appropriate terminology, styles, and methods. So 3.1, communicate legal information in writing using appropriate terminology, styles, and methods. Functions of legal language: to establish rights and obligations, to distribute information, to enable communication within the legal profession. So we're going to look at what is legal writing. Legal writing involves the analysis of fact patterns and the presentation of arguments in documents, such as legal memorandum and briefs. One form of legal writing involves drafting a balanced analysis of legal problem or issue. Another form of legal writing is persuasive and advocates in favour of a legal position. Now we'll be looking more at drafting later on. So the functions of legal language: learning legal terms is important for your career. If you are studying law, regardless of the country, the main reason behind this is the rise in globalization. Since a lot of people studying from one country and apply their learned skills by moving to another country, it's important that you should be able to communicate well while interacting with others. When you enter into the market as a qualified lawyer, you will come across various clients in your country and you have shifted to. Similarly, you will have to use all the legal terminologies that other lawyers use in that region. For instance, if you have studied law from Brazil and you want to practice in the United States, you will most likely interact with US attorneys. In order to talk to them regarding legal matters, you must adapt their legal language. For example, English used in law that is particular to their region. Universal features of legal language. So some universal features of legal language is extreme precision, obscurity, ambiguity, anachronism, wordiness, redundancy, lengthy and complex sentences, and terms of art and technical terminology. Effective communication for lawyers is an essential guide to communicating in the radically and rapidly changing environment of the profession today. It connects theory to practice in order to improve client communication, support the transformation of legal work, and prepare people for the future. Effective communicating one's work is a key stage of a lawyer's career. As a student at law, it will be a daily task to report to your supervising lawyer on the research conducted, or to prepare the first draft of a small claims court claim, or to present summary of a file, or to write a blog for the firm's website about a recent case. The successful performance of these tasks will depend on legal writing skills of the student. If they can write effectively, communicate in written form, the reader will fully comprehend the analysis without having to retrace all of the steps needed to take to get to that conclusion. Professional legal communication. Now, when we look at professional legal communication, there's elements of that need to be looked at in regards to this. So writing emails, they have to be professionalism. So you need to be using proper email language, conveys a professional image. Efficiency. So these emails that get to the point are more effective. Protection from liability. So staff awareness of email risks protects your firm from costly lawsuits. Writing emails to clients and colleagues also requires effective written communication. Lawyers must be able to write emails that are professional, as we've just stated, clear and concise, while also being respectful and courteous. Emails that are poorly written or contain errors can harm a lawyer's reputation and lead to misunderstandings or disputes. Minutes of meeting. So the function of minutes of meeting is to document the minute at the meeting, to present information, and the agenda item should contain summary of the views expressed. It should be very clear, a memorandum, minutes of association, a clear statement reporting how each issue was resolved, procedure for taking minutes, be aware of the agenda, know the names of the participants, and sit near the chair and write up minutes immediately after the meeting. Legal communication, client care letters. The purpose is a duty to keep client informed. It is a duty to explain the law in plain English. It's a duty to discuss all relevant information, considerations, negative and positive. It's a duty of condor, duty to preserve client confidentiality, and the form is that it is review relevant facts, explain governing laws, assess situation in light of law, and recommendations and closing paragraphs. Client care letters summarises the key information which the client of a solicitor's firm needs to know about how the legal matter is going to be dealt with. Strictly speaking, the Solicitors Regulation Authority, the SRA Code of Conduct, only require the information on how to make a complaint to be in writing. The SRA has scrapped virtually all of the prescription which used to be in place about the need to have a client care letter and what you have to include. There's much flexibility now. However, in practice, solicitors will need to clearly set out for the clients key information about the case, such as how the firm can help, costs, who is dealing with the case, how long it will take. A covering letter to the terms of the business remains the most popular way to do this, and this is called a client care letter. Most solicitors' client care letters, and surprisingly even many of the templates available, fall short of the SRA's new expectations for this document. There has been a dramatic shift in the standards required. Solicitors Regulation Authority loads lengthy detailed client care letters full of text and boilerplate details. The SRA look at the following issues in regards to a good client care letter. Is your client care letter concise? It should not be too lengthy. That the SRA encourages firms to think about whether some information could be separated out, such as into the terms of business. Number 2, is it easy for the client to read and in plain English? The client care letter should avoid legalistic language or jargon, particularly for vulnerable clients. This is less of a concern if you are working with legally experienced clients, but fundamentally you need to be certain that clients can quickly understand your communications. Number 3, do they highlight the key issues, such as by using headings, bold text or text? The templates, should they identify the clear issues and the facts of the case? Number 4, do they explain what is going to happen and when? It can be difficult to give an exact timescale for completion of a matter. However, you should at least be able to give the client some idea of it. It's between 2 brackets or split it in different eventualities. Also, the SRA look at it if it's clear and how much the matter is going to cost. So you must give the client the best possible information about their legal matter is going to cost overall. They also look at, is it obvious to the client of what they need to do next? So this is another area where many of the client care letters tend to fall short. Often what the client needs to do is littered piecemeal over the 12 pages with identification detail within 1 page. and also they need to, the SRA identify that it is clear what the purpose of the client care letter is, and have you tailored the letter according to the client. Remember the basic rules of drafting. To draft effective documents, you must understand the client's goals, identify the issues triggered by the period or case at hand, research the laws concerning the issue. You should apply the research relevant to the case, and you should communicate the terms to your audience. Legal drafting is a writing process that manipulates facts to achieve a predictable and planned legal result. Your client desires. Lawyers are often required to prepare documents that make the law operate in such a manner as to accomplish the client's goal. Drafting legal documents requires effective written communication, as lawyers must be able to clearly and accurately communicate complex legal concepts and ideas in a manner that is understandable to the clients, judges, and other legal professions. Legal documents such as contracts, wills, and other legal agreements must be written in a way that is clear, concise, and unambiguous to avoid any misunderstanding or disputes. The legal drafting process. Firstly, you need to identify the issues and understand the client's goals. Secondly, you need to identify the facts that define what must be addressed in the document. Thirdly, research the law implicated by the facts. Fourthly, use the law and facts to state the terms of the document that will accomplish the client's goal. And fifthly, communicate the terms to the client. Drafting legal documents is a skill that improves over time. With practice and attention to detail, you will eventually become more proficient in creating documents that effectively communicate legal concepts and arguments. So, in regards to the importance of communicating any sort of documents or information in legal writing, it's very important in regards to the legal profession that everything is done according to the law, the Solicitors Regulation Authority, like the example we give, what they expect you to do in client care letters. Also, you need to make sure that you're writing emails, drafting documents is done in a professional and concise and clear manner for the person to understand. And, communication is really, really important in regards to use the legal environment. And the main reason behind this is that the fact that everything needs to be concise, proficient for the person to understand, and, be able to communicate with others in regards to it. Some of the references that have been used for today's session is Hanson S 2015 Learning Skills, Legal Skills and Reasoning by Routledge, Ingalls MB Legal English Communication Skills, Morgan Lawyering Skills and the Legal Process, Webley Legal Writing, and Werish MH 2009, which is Legal Writing and Ethical Professional Considerations. So thank you for attending today's session. Thank you for your patience. And we've finished the session now, and I will see you in the next class. Thank you.